welcome to our live lecture session of Swayamprabha channel. My name is Riya Pramanik. So we are currently studying about Indian government and politics, which is BPSC 132. The code of the course is BPSC 132. So today we will be talking about block 3, that is about institutions. In this part, I will be talking about unit 8, that is executive, and unit 9, that is judiciary. So let's start with it. We will starting with our session today with unit 8, that is executive. We will be talking about it, and in my previous lecture also I have started with few things of this unit about president, but now we will be moving forward in this chapter. So let's start with the powers of the president. This is a very important thing which we need to learn by heart, because all these powers are mentioned in our constitution, and these articles which talks about the powers of the president are very important. So the executive powers of the union are vested in the president. So as we are talking about executive, so all this executive power of the union is vested in the president. So Article 53 confers that all executive powers in him and empowers the president to exercise these powers directly by himself or through officers subordinate to him. Article 75 requires the Prime Minister of India to communicate to the President regarding all decisions of the Union Council of Ministers. That means whatever is happening in our country, it is the duty of the Prime Minister to communicate it with the President regarding all the decisions taken. Article 77 talks about that all executive powers of the Union government shall be exercised in the name of the President. So whatever executive things are going on in our country, all these powers of the union government shall be exercised in the name of the president. Power is divided into two types. The president's power is divided into two types. The first type is ordinary powers, and the second one is the emergency powers. The ordinary powers of the president can be defined as executive, legislative, financial, and judicial powers. So I will be talking about the emergency power of president in detail in our next slides. The president has both administrative and military powers as well. The supreme command of the armed forces is vested in him or her. So the armed forces supreme command is vested in the president. All appointments in the armed forces are made under the authority of the president as the supreme commander. So the president also appoints the prime ministers on letters advice. The council of ministers, that means president is the one who is appointing the prime minister, and on the advice of prime minister, he or she also appoints the council of ministers, the attorney general, the justices of the Supreme Court and High Court, members of special commissions like UPSC and the Election Commission, and the governors of the state. The President of India has the power to declare war and conclude peace. The power to declare war within any country or to declare peace after facing a war, this power is vested in the President. But all these powers had to be exercised by him subject to the ratification of the Parliament. So it is not like that all these powers should be taken by him only. But if he takes that decision, after that also he has to go with the ratification by the Parliament. So the President has the power to summon both houses of Parliament. Next power of President is that he or she nominate 12 members to the Rajya Sabha. Also, the President has the right to address either house or their joint session at any time, and the power to dissolve the Lok Sabha. All money bills to be introduced in the Parliament have to obtain the recommendation of the President. Any bill passed by the Parliament can become an act only when it has the assent of the President. So, whatever bill is discussed in the Parliament, it can become a law or an act after the signing by the President. Next comes that when the Parliament is not session, the President can promulgate ordinances in public interest. These ordinances have the same force and effect as the laws passed by the Parliament. So this is a power which is vested in president, that he or she can, uh, when there is no parliament in the session, the president can promulgate these ordinances in public interest. However, they have to be placed before the parliament within a period of 6 weeks. Without the parliament's approval, the ordinance will become invalid. So, whatever the president is doing, all these things have to be ratified by the parliament after a certain period of time. So Article 254 talks about that the president to remove inconsistencies between laws passed by the parliament and the state legislatures and the subjects included in the concurrent list. Also, the judicial power of the President of India includes the appointment of the justices of the Supreme Court and High Court. So, it is the President who is appointing the judges in the Supreme Court and the High Courts. Later, we can say that the president also has the power to grant pardon, reprieve, suspension, remission, or commutation of punishments or sentence of the court. These powers of granting pardon are given to the president for removing the extreme rigidity in the criminal laws. So, there are many cases where criminals can appeal to the president for mercy. So, these powers of granting pardon in the criminal laws and for protecting the persons on humanitarian conditions. So, the president also has the right to seek the advice of the Supreme Court on some important constitutional, legal, and diplomatic matters. So, in 1977, the president sought the advice of the Supreme Court for creating special courts to try the emergency cases. Next comes, let's talk about the emergency power. So, up to the last slide, we have talked about the general powers of the president, the ordinary powers about the president. Now we will be moving forward to understand the emergency powers which is vested in the president. So, the Constitution of India bestows emergency powers on the president of India. The president is empowered to declare three types of emergencies. So it is to be remembered that whenever there is any kind of emergency imposed in our country, it should be imposed by the president only. It is the president who will declare about it. So, national emergency arising out of the war, external aggression, or armed rebellion. So, this is one type of emergency that the president can impose. Second emergency is which arise due to the breakdown of the constitutional machinery in the states, and the third is the financial emergency. So the president can make a proclamation of national emergency at any time if he or she is assured that the security of any part of India is threatened by the war. So it is up to the president to declare emergency in the country, and if he is assured that there is any security issues in any part of India, then he can he can proclaim this national emergency on the basis of the threatened by war. If India is threatened by war, or there is any external aggression or armed rebellion, this proclamation of emergency must be submitted to the parliament for its consideration and approval. If the parliament fails to approve the proclamation bill, it ceases to operate, and if approved, it can continue for a period of 6 months. So, after declaring emergency, the decision should be approved by the parliament, and if it approves it, the parliament, if approves it, then it will continue for a period of 6 months. However, it can continue for any length of time if the president approves the proclamation of for every 6 months. So it can also continue beyond 6 months as well. So, National Emergency Article 352 was proclaimed for the first time in 1962 when the Chinese aggression took place. So, as we all know, that in India we have saw the Indo-China War in the year 1962, and that was a very tough period for India because in 1947 we got independence, and after that we have seen the all the riots regarding partition at that time, and then after few years only we saw the Indo-China War in the 1962. This was the time when national emergency article 352 was proclaimed. So the second proclamation of emergency was made in the year 1971 during the Bangladesh War. So the first time the emergency was imposed due to the 1962 Indo-China War. Second time it was proclaimed for Bangladesh crisis that happened in the year 1971. On 25th June 1975, for the very first time, the president proclaimed on the advice of the prime minister emergency in the name of grave danger to internal security. This was the very first time when, on the grounds of internal security, like danger to internal security, was the ground for proclaiming the emergency. That happened in the year 1975, 25th June. According to Article 356, the president can impose emergency in a state when there is a breakdown of the constitution machinery. However, imposition of president rule in a state has become more difficult after the Supreme Court verdict in a case known as Bommai case. So there is also a provision which allows a president to impose emergency through Article 356 in any state if there is any breakdown of the constitutional machinery over there. So this role of the president, or this power of imposing emergency by the president, or it is known as president's rule in a state, has become more difficult due to the Bommai case. There was a Supreme Court verdict. Bommai case was a very famous verdict. According to that, the imposition of president's rule in any state become a little bit difficult. According to this case, the president can dismiss a state government only after the approval of the proclamation by both the houses of the parliament. So this was a thing which have to be taken care of before imposing the president's rule. So the proclamation of this type of emergency, popularly called as president rule, as we have discussed, which can remain in force for a period of 6 months. So once imposed in a state, this emergency will move. This emergency can continue for a period of 6 months. So by the 44th Amendment, the Parliament can extend the duration of state emergency for a period of 6 months at one instance. Ordinarily, the total period of such kind of emergency or president rule can't exceed 1 year unless there is a national emergency in force. So, this president's rule can't exceed for over 1 year. However, the total period of state emergency can't go beyond 3 years. So, there are few time periods for which this kind of president's rule can be proclaimed. Article 360 states that if the president is satisfied that a situation has arisen where the financial stability or credit of India or any part of the country is threatened, he or she may declare financial emergency. So, in case that India is facing financial problem, there is no credit of India. So, at that point of time, if president is agreed on these kinds of situation, at that point of time, he or she, the president, can impose financial emergency. Like the national emergency, such a proclamation has to be laid before the parliament for its approval. So, whatever the emergency would be, it should be ratified or it should be laid before the parliament for the approval. Now, let's move forward to know about prime minister. He or she, the prime minister. The post of prime minister is considered to be the head of the government. So the real executive power under the constitutions vests with the Union Council of Ministers, with the prime minister as its head. So who is prime minister? He is the head of the Council of Ministers, which executes all the things in our country. It executes all the plans, all the policies in the government. So the president is obliged to act according to the advice of the Council of Ministers, which is responsible in the real sense of the term, not to the president but to the Lok Sabha. So the Council of Ministers is accountable to the Lok Sabha. As in Britain, the Prime Minister of India is usually a member of the lower houses of the parliament. So, like Britain, in Britain, the Britain's Prime Minister, the British Prime Minister belongs to the lower house of the parliament. Similarly, Indian Prime Minister also is a member, should be a member of the lower house of the parliament, which is known as Lok Sabha. When Indira Gandhi was selected as a prime minister in the year 1966, she was the member of the Rajya Sabha. So, by getting elected to the Lok Sabha, like because she was elected to the Rajya Sabha and not Lok Sabha, later on she got elected in the Lok Sabha as well, and she strengthened the convention of the prime minister being a member of the lower house. So the prime minister is appointed by the president, as we have learned about it in the section where we were talking about the powers of the president. It is the president who appoints the prime minister. However, president has hardly any choice in selecting the prime minister. Suppose, for example, we can say that it is the president who is appointing the prime minister, but there is hardly any choice to the president, because the majority party's leader becomes the prime minister and he or she is elected by the popular votes. So he or she can only invite the leader of the party in majority in the Lok Sabha, or a person who is in a position to own the confidence of the majority in the house. So if there is one party which comes with thumping majority or majority, normal majority, the leader of that party will become the prime minister. Also, there are many cases where no party could arrange majority after elections. In that case, a person who is in a position to own the confidence of the majority in the house will become the prime minister. The president appoints the other members of the council of ministers on the advice of prime minister. So it is the prime minister who decides who will be in the council of ministers, and after that only, after the advice taken from the prime minister, the president appoints them. Let's talk about the council of ministers and the cabinet. So the term cabinet is used interchangeably with that of council of ministers, but they are different. So there is a difference between cabinet and the council of ministers. So it is very important to know what is the difference between these two terms, which is often used interchangeably. So the council of ministers or the ministry consists of different categories of ministers. So if we talk about council of ministers or ministry, it consists of different categories of ministers. At the time of independence, there was no such institution as a cabinet in India. So the term cabinet was not that much popularized during the early times when India got independence. What existed then was the Executive Council. On 15th August 1947, the Executive Council was transformed into a ministry or council of ministers that is responsible to the parliament. So, before independence or at the time of independence, there was no cabinet as such or council of ministers as such. There was only Executive Council, but on 15th August 1947, this Executive Council was transferred into the ministry or council of ministers. The term cabinet was used thereafter as an alternative to the council of ministers. So, it is used alternatively with the term council of ministers. At this stage, all the members of the ministry or the cabinet except the prime minister had the same status. So in 1950, based on the recommendations of a special committee which was headed by Gopalaswamy Iyengar, and it's known as Gopalaswamy Iyengar report, a three-tier system of the ministry was established, with the cabinet ministers at the top, ministers of the state at the middle, and the deputy ministers in the lowest rank. So, according to this Gopalaswamy Iyengar report, the ministry was divided into three tiers. So, what was the first level? It was about the cabinet ministers. They were in the topmost level of this three-tier system. In the second rank, it is ministers of the state, and in the third, it is the deputy ministers, in which comes in the lowest rank. So the cabinet, composed of the senior most ministers whose responsibilities transcend departmental boundaries into the entire field of administration, is a smaller but most powerful body in the government. So the cabinet ministers are the senior most ministers, and the number of these senior most ministers in the government is low, but it is the most powerful body in the government. So let's talk about what are the functions that cabinet used to play. So the cabinet serves three major functions. It is the body. The first one is that it is the body which determines government policy for presentation to the parliament. So it is the function of the cabinet which determines the government policy for presentation to the parliament. Second is it is responsible for implementing government policy, and third is it carries out interdepartmental coordination and cooperation. So these are the major functions of the cabinet or the cabinet ministers. The cabinet meets regularly as it is a decision making body. So please remember that the decision making body in the parliamentary form of government is the cabinet ministers who decides what steps or what should be done in the future. It is assisted by the cabinet secretary. So to assist these ministers in the cabinet, there are cabinet secretariats headed by a senior member of the civil services, the cabinet secretary. So the senior most person or the senior most officer in the bureaucracy is given this task to become a cabinet secretary who will be helping or assisting the cabinet ministers. To manage the volumes and complexities of the work that comes before it, the cabinet members have developed standing and ad hoc committees. So there are many standing and ad hoc committees. So there are four standing committees which are permanent in nature. These are the first committee, first standing committee is Defense Committee, Economic Committee, Administrative Organization Committee, Parliamentary and Legal Affairs Committee. So these are the four standing committees which are permanent in nature. Next thing, so this is all about cabinet. Next in rank are the ministers of state who hold independent charge of individual ministries. So next comes the ministers from the second rank, that is the ministers of state. They hold independent charge of individual ministries and perform the same functions and exercise the same powers as a cabinet minister. The only difference between minister of state and a cabinet minister is that he or she is not a member of the cabinet but attends cabinet meetings only when specially invited to do so in connection with the subject that he or she is given charge of. So what is the difference between minister of states and the cabinet minister is that first of all, they are not a part of the cabinet. Secondly, they are only they can only attend any cabinet meetings when they is invited. So if they are not invited, they can't attend any meeting. So they are usually invited in a meeting which has connection with the subject that the particular minister of state is given charge of. So at the bottom of the hierarchy are the deputy ministers who do not have specific administrative responsibilities. However, their duty includes many things. So, they are not given any specific administrative responsibilities, the ministers of the third rank, but they have some duties to play. So, the first duty that they used to play is that answering the questions in the parliament on behalf of the ministers concerned and helping to pilot bills. So, what is the first duty of these ministers, deputy ministers, is that they have to answer the questions asked in the parliament on behalf of the ministry they are assigned to and helping pilot the bills. Next is explaining policies and programs to the general public and maintaining liaison with members of parliament, political parties, and the press. So the second duty which are they assigned is that about the explaining the policies and the programs to the general public. It is very important for the government to communicate with the public. What are they doing? What are they planning? That should be discussed with the general public so that they can understand the policies better. So, it is the duty of the deputy minister to explain these policies and programs to the public and maintain the liaison with members of parliament, political parties, and the press. Undertaking special duty or investigation of particular problems. So, the third duty of these deputy ministers is that they have to undertake special duty or investigate particular problems which may be assigned to them by particular minister. So this is the roles that deputy ministers play in the government. So the cabinet is considered to be the nucleus of the council of ministers. Precisely because of this reason, Walter Bagehot calls the cabinet the greatest committee of the legislature. So according to Walter Bagehot, what he discussed about the cabinet. So according to Bagehot, cabinet is the greatest committee of the legislature. It is the connecting link between the executive and legislative power. So because in a parliamentary system of government, it is not separate. So the executive and legislature is not separate from each other. So this cabinet plays a link between the executive and legislative power. Let's talk about the collective responsibilities. So, the Council of Ministers function on the principle of collective responsibility. Under this principle, all ministers are equally responsible for each and every act of government. So, whatever the decisions, whatever the policies and programs are undertaken by the government, decisions taken by the government, so there is a collective responsibility, and they are responsible for each and every decisions or act of the government. That is, under the collective leadership, each minister accepts and agrees to share responsibility for all decisions of the cabinet. So it is not like that you are a part of the council of ministers but you don't agree with a particular policy. In that case, it is believed that you will resign from that post if you have any kind of disagreements or any kind of problem with the policies, certain policies. So apart from this issue, we can say that the council of ministers take collective responsibility of any act of the government. Once a decision has been taken, it has to be loyally supported. So it is believed that the ministers will support the decisions once taken and considered as the decisions of the whole government. So one cannot say that why this agriculture department is doing this, why this agricultural minister is talking about this, I don't support. So no minister can say this, because it is the collective responsibility of all the ministers to support and to they have to consider this decision of the whole government collectively. So even if the council of ministers is formed as a result of a coalition of various political parties, a minimum common program becomes essential for maintaining the solidarity of the ministry. So in a case where there is no majority party in the government and there are many parties in a coalition are running the government, in that case the ideologies, the agendas, these all things varies between the political parties. In that case, when there is a coalition government, there is some kind of minimum common program on which they have to agree. Like there should be few points on which they agree so that the government can run smoothly. So in that case, there are minimum common program which is essential in a coalition government for maintaining the solidarity of the ministry, and various political parties forming the coalition government have to stand behind that program. So if there is a coalition government, so the ministers have to agree on certain minimum common program. Let's talk about the cabinet and the parliament. The core of the parliamentary government is the accountability of the prime minister and the cabinet to the parliament. So, as I already said, that there is a link between the executive and legislature in the parliamentary form of government. So, from here we can say that the executive is responsible towards the legislature or towards the parliament. So, it is the responsibility of the executive to present before the parliament and answer the questions if asked. So the parliament does not govern but critically examines the policies and acts of the government. So because it is the prime minister is the part of the legislature, and the executive is a part of the legislature. So in that case, the there is a right of the parliament to see or to critically examine each and every policies and acts of the government, and it can also approves and disapproves of them as the representative of the people. So because parliament is the representative of the people. It represents the entire citizens of the country. So it is the responsibility or the duty of the parliament to see whether all the policies and programs undertaken by the government is good or bad. So the very existence and survival of the prime minister and the council of ministers depend upon the support they receive in the parliament. So the survival of the prime minister depends on the parliament. Thus, there is a general feeling that the parliament controls the executive. So, after learning these points, we can say that it is the parliament which controls the executive. But in reality, the prime minister, with his majority support, controls the very working of the parliament. So, initially, it may seems like it is the parliament which is controlling the executive, but in reality, it is the prime minister which controls the parliament, because the prime minister belongs to whatever party has the majority of the public. So let's talk about the sources of prime minister's power and the influence. So though the constitution does not enumerate the powers and functions of the prime minister, in practice prime ministers enjoy a wide range of powers as a leader of the council of ministers and the Lok Sabha. So prime minister is not only the leader of the council of ministers but also the Lok Sabha. So there are many powers and many functions which a prime minister should play. So the prime minister's prerogative of constituting, reconstituting, and reshuffling the ministry. So it is on prime minister whether he want to reshuffle his ministry or not. Also, chairing the meetings vests the office with considerable influence over the members of the parliament. So it is the duty of the prime minister to chair the meetings, and the prime minister has the freedom to select his colleagues. So suppose there is a prime minister, he wanted to create a council of ministers. So it depends on the prime minister only whom he want to take in his cabinet or in his council of ministers. So it depends on them, and it is subjected to his or her own position within the party. So the prime minister also derives power and influence from the fact that he or she is the leader of the majority party in legislature, and sometimes even the leader of the parliamentary wing of the party. So he has all these powers. And also, as a leader of Lok Sabha, the prime minister has enormous control over the parliamentary activities. So earlier it was like that parliament is controlling the executive or the prime minister, but in reality we can say that the prime minister has enormous control over the parliamentary activities. He or she advises the president on summoning and prorogation of the sessions of the parliament, and the speaker consults the prime minister in finalizing the agenda of the Lok Sabha. So the speaker of the Lok Sabha talks or consult the prime minister in finalizing the agenda. The most important power of the prime minister regarding the parliament is to recommend dissolution of Lok Sabha. So this power, whether the Lok Sabha should be dissolved or not, is vested with the prime minister. The president has to accept the advice of the prime minister. So president is bound to accept the advice of the prime minister. It has also the power by which the prime minister controls even the opposition. So these are the sources of prime minister's power, and all the major appointments of the central government are made by the prime minister in the name of the president. So we can say that the president of India is only the titular head. All the real powers lies with the prime minister. So the major appointments in central governments are done by the prime minister in the name of president. It includes chief justices, judges of the Supreme Court and High Courts, attorney generals, the chiefs of the army, whether navy, air force, or army, then governors and the chief of members of the election commission, etc. Apart from these structural factors, there are other features that increase the power and authority of the prime minister as well. So in several instances, we can say that in general elections in most democratic systems virtually become an election of the leader, and it is interpreted as a popular mandate. So in many times we have saw in India that people used to vote in the name of the leader, not on the basis of the political party. So it also gives power to the prime minister. Now let's talk about the president and the prime minister. So Article 78 enumerates the duties of the prime minister. The prime minister is to communicate to the president about all the decisions taken in the council of ministers relating to the administration of the affairs and the union and proposal for legislation. So whatever is happening in the parliament should be communicated to the president by the prime minister. It also furnished such information relating to the administration of the affairs of the union and proposals for legislation as the president may call for. These duties of the prime minister seem to suggest that the president is the real executive, but as we saw, president can exercise his powers only with the aid and advice of the council of ministers. Therefore, prime minister heading the council of ministers is the real executive. So let's move forward to Unit 9, that is judiciary. So we have completed in our previous session about legislature. Now I completed executive and now we are moving forward towards the judiciary. These were the three organs of the government. So let's talk about the evolution of judiciary in India, from where it evolved. So the evolution of the contemporary judiciary in India can be traced to the colonial period. So as we all know that India went through a colonial period for a very long time. So we can see that judiciary comes from there only. It was with the Regulating Act of 1773 that the first Supreme Court came into existence in India. So the first Supreme Court came into existence in India after Regulating Act of 1773. The first Supreme Court was located in Calcutta because Calcutta was the capital of the British colonial system, British colonial government. So it was located there only. Currently, Calcutta is known as Kolkata, but at that point of time, it was known as Calcutta. So, located at Calcutta, the Supreme Court consisted of Chief Justice and 3 judges. Subsequently, it was reduced to 2 judges. So, initially, there was 1 Chief Justice and 3 judges, but subsequently, it was reduced to 2 judges appointed by the crown. So, all these judges were appointed by the crown. The crown means the king or the queen of England, and it was made a king's court rather than a company's court. So companies comes here because of the East India Company, which came to India for a business perspective, but later on they remained here and they started ruling us. So the judicial system during this period consisted of 2 systems: the Supreme Court in the presidencies and the Southern courts in the provinces. So there were 4 presidencies at that point of time, and these Supreme Courts were in the presidencies, and in other provinces there were Southern courts. While the former followed the English law and procedure, the latter followed regulation laws and personal laws. So this is very important to understand that initially where Supreme Court of India just evolved in the colonial period, the Supreme Court was followed by the English law and procedure, whereas the Southern courts, which existed in the provinces, they were followed by the regulation laws and personal laws. So, if for example, if there are many Southern courts in India, so it doesn't mean that all Southern courts have same laws or same uniform laws all over India. It depends on the personal laws, where people from that particular area have different personal laws as compared to others. So, the Federal Court of India was established in Delhi by the Act of 1935. So, the first federal court, it was established in Delhi by the Act of 1935, and it was to act as an intermediate appellant between the high courts and the privy councils regarding matters involving the interpretation of the Indian Constitution. So the federal court has advisory as well as original jurisdiction in certain other matters. So it was very important court at that point of time. This court continued to function until 26 January 1915. So we can say that it started from 1935 onwards, and it continued till 1950, the day independent India's constitution was implemented. So as we all know that our constitution was already prepared on 26 November 1949, but it was uh, came into existence and came into force from 26 January 1950, where from on which day we celebrate our republic. So it the federal court functions till the 26 January 1950. Now let's talk about Supreme Court. So the entire judicature has been divided into three tiers. So the judiciary system, the judicature has been divided into three tiers, and at the top of all these three tiers is the Supreme Court of India. Below it, it is the High Court, which exists in states, and in the lowest rank is occupied by the Sessions Court. So Session Court, then above that is High Court, and at the top it is Supreme Court. The Supreme Court is the highest court of law. So as the name suggests, it is the Supreme Court, and that's why it is the highest court of law. The constitution says that the law declared by the Supreme Court shall be binding on all small courts within the territory of India. So whatever decisions is taken by the Supreme Court, all the small courts or session courts or high courts are bound to follow that. So given the importance of the judiciary in a federal system resting on limited government, the Supreme Court was designed to make it the final authority in the interpretation of the constitution. So our constitution makers didn't allow the parliament as the final authority in interpreting the constitution, but it is the judiciary, it is the Supreme Court which is designed to make the final decisions regarding the constitution. So constitutional assembly gave a great deal of attention to such issues as the independence of the court. So there was an issue like independence of the court. It is very necessary to provide the fairness or justice to all, each and every person of the India. So the power of the Supreme Court and the issue of judicial review. So the Constitution Assembly, they gave a great deal of attention to the issues as the independence of the court, the powers of the Supreme Court, and the issues of the judicial review. Let's talk about the composition and appointments in the Supreme Court. The Supreme Court consists of the Chief Justice of India and not more than 26 other judges. So, what is the composition of Supreme Court? There will be one Chief Justice and not more than 26 other judges. When the Supreme Court was inaugurated, it had only 8 judges. So initially, when Supreme Court was inaugurated a very long time back, at that point of time, there were only 8 judges. With time, it has risen to 26 judges because our country is a very large country with huge population, and to impart justice to all on time, it was necessary to increase the number of judges in the Supreme Court. Avoiding political interference in the appointment of the judges of the Supreme Court, some important qualifications have been set for the post, such as, so now we will be talking about what are the qualifications which is compulsory for a person to have to become a judge of the Supreme Court. So the very first qualification is the person should be a citizen of India. No persons belonging to other countries can become a judge in our Supreme Court. He or she must be a citizen of India. Second, a judge of the High Court for at least 5 years. So if a person is a judge in the High Court for 5 years minimum, then he can be appointed as the judge of the Supreme Court. The third qualification is that he or she should have been an advocate of the High Court for at least 10 years. So if a person is a judge in the High Court for 5 years, he or she can be appointed as the Supreme Court judge. If he is not a judge of the High Court, then if he or she is the advocate of High Court for 10 long years, then also they are allowed to or they can be appointed to the Supreme Court. Fourth one is distinguished jurist in the opinion of the President of India. So all these are the criteria which need to be fulfilled by a person to become a Supreme Court judge. So let's talk about the tenure of the judges. So once appointed, a judge holds office until he attains 65 years of age. So once appointed, the judge holds the office until 65 years of age. So the tenure of a judge is 65 years, and a judge of the Supreme Court may resign his office or may be removed in case of misbehavior or capacity. So it is very important to know that the Supreme Court judge can be or may resign from the office or may be removed also. So, in what case they can be removed? The first is misbehavior, and second is incapacity. So, according to the procedure laid out in the Constitution, each house of the Parliament will have to pass a resolution supported by two-thirds of the members present and voting. So, there is a constitution where there should be a resolution passed by the Parliament supported by the two-third members present and voting. The motion of impeachment against a judge was tabled in Parliament for the first time in 1991. So, since its inception, it is in the year 1991 that an impeachment against a judge was tabled in the Parliament. So, it involved Supreme Court Justice V. Ramaswamy. So, he was the judge against whom the impeachment was tabled in the Parliament. Let's talk about the jurisdiction of the Supreme Court. Article 141 declares that the law laid down by the Supreme Court shall be binding on all courts within the territory of India. We have discussed about it, but it is Article 141 which declares it. So there are different categories into which the jurisdiction of the Supreme Court is divided. So first is original jurisdiction, appellate jurisdiction, advisory jurisdiction, and review jurisdiction. So let's talk about the original jurisdiction. The Supreme Court has original jurisdiction initially as a federal court. Under Article 131, the Supreme Court is given exclusive jurisdiction in a dispute between the union and a state, or between one state or another, or between a group of states and others. So in case there is a dispute between the union and the state over some issues, or state versus state, in that matters, it is the Supreme Court which is given the exclusive jurisdiction by our Constitution under Article 131. The original jurisdiction of the Supreme Court will mean that the parties to dispute should be units of the federation. The Supreme Court also has an extensive original jurisdiction as the protector of the fundamental rights. So, in the part of fundamental rights, we have discussed that. So, we know that the Supreme Court has the extensive original jurisdiction as the protector of the fundamental rights. If someone is not given or someone is denied fundamental rights, he or she can move to the Supreme Court directly. Article 32 of the Constitution gives the citizen the right to move the Supreme Court directly for the enforcement of any of the fundamental rights enumerated in the Part 3 of our Constitution. Let's talk about the appellate jurisdiction. Supreme Court has comprehensive appellate jurisdiction in cases involving constitutional issues, civil and criminal cases involving specified threshold values of the property or death sentence, and a wide-ranging powers of special appeals. So, Article 132 of the Constitution provides for an appeal to the Supreme Court for any judgment or final order of a court in civil, criminal, or other proceedings of the High Court. Article 133 of the Constitution provides an appeal in civil cases lies to the Supreme Court for any judgment, order, or civil proceedings of the High Court. And also Article 134 deals with this only, and it provides the Supreme Court with appellate jurisdiction in criminal matters for any judgment, final order, or sentence of a High Court. Let's talk about the advisory jurisdiction. The Supreme Court is vested with the power to render advisory opinions on any question of fact or law that may be referred to it by the President. The practice of seeking an advisory opinion of the Supreme Court helps the executive to arrive at a sound decision on important issues. Let's talk about review jurisdiction. The Supreme Court has the power to review any judgment pronounced or order made by it. So, in any court, if there is a judgment pronounced, Supreme Court has the power to review that judgment. It means that Supreme Court may review its judgment order. So, now let's talk about the High Court. Chapter 5 of Part 6 from Article 214 to 231 of the Constitution of India contains provisions regarding the organizations and functions of the High Court. The Parliament has the power to establish a common High Court for two or more states. There is no minimum number of judges for the High Court. So, as we have read in part of Supreme Court, that there should be one Chief Justice and 26 judges, Supreme Court judges. But in High Court, the number of judges is not fixed. The President from time to time will fix the number of judges in each High Court. It is upon the President to decide. A judge of a High Court normally holds office until he attains the age of 62 years. The original jurisdictions of a High Court includes enforcement of fundamental rights, settlement of disputes relating to the election to union and state legislatures, and jurisdictions over revenue matters. So, this High Court exists in all the states. Not all states, some states don't have High Courts. They have High Courts in a particular area or a particular state, whether they have to move. So, a judge of the High Court normally holds office until he attains the age of 62 years. So, in case of Supreme Court, we have seen that it is the 65 years, which for 65 years of age of the Supreme Court judge is allowed, whereas in case of High Court, it is the 62 years. Now, let's talk about the subordinate courts. Under the High Court, there is a hierarchy of courts which are referred to in the Indian Constitution as subordinate courts. So, the first tier, as we have talked about, is about the Supreme Court. Next comes the High Court, and then the subordinate courts or the lower or session courts. So, under the High Court, there is a hierarchy of courts which are referred to Indian Constitution as subordinate courts. So, under High Court also there are few hierarchies, and they are referred to as the subordinate courts. Since these courts have become into existence because of the enactments by the state government, their nomenclature and designation differ from state to state. So, the existence of these kinds of subordinate courts was enactments of the state government. They existed because of some enactments done by the state governments, and because of that, their nomenclature or the designation of designations of the judges differs from state to state. However, there is a uniformity regarding its organizational structure. So, there is some kind of uniformity in it. The Constitution ensures the independence of the subordinate judiciary. Appointments to the district courts are made by the governor in consultation with the High Court. So, appointments to the district courts are made by the governor of the state in consultation with the High Court. So, according to our Constitution, it is the President which decides the judges and which decides anything about the judges in the Supreme Court and High Court, but it is the governor of the state which decides the appointments or which appoints the district courts or the district judges of the district courts with the consultation of the High Court. So, this is we have read about the judiciary and executive in our class. So, one of the main thing which you need to understand is the powers of the president, which is very important, and the prime minister's role and tenure and all the important things which is given in our constitution. So, in today's lecture, to revise what we have already done in today's lecture is that we have talked about the powers of the president, what are the roles he or she has to undertake being a president of India, but it is considered to be a titular role which the president used to play in our country. So, as I already talked about the difference between the presidential form of government and the parliamentary form of government, though there is prime minister and president exist in a parliamentary form of government, the real executive or the main power lies with the prime minister and not the president. Whereas in a presidential form of government, the real executive is the president. So there is a difference between these two forms of government. In presidential form of government, we can see that there is no connection between the legislature and the executive, they work separately. If someone is a member of the executive, he can't become a member of the legislative, and vice versa. Whereas in a parliamentary form of government which exists in India, which we inherited from the Britain, so in our form, in the parliamentary form of government, there is a link between executive and the legislature, as we have already read that it is the prime minister is the leader of the Lok Sabha. That means he is also present in the legislature and also working as an executive. Also, all the members of the councils also belong to legislature. They debate in the parliament, they take decisions, they make laws, and then they go and execute according to the plan. So there is a difference between presidential form of government and parliamentary form of government. Because we have parliamentary form of government in our country, it is the prime minister who is more important and who plays major roles in our country, or to run the government in the country, and it is the titular role which is given to the president of India. Also, we should understand why this distinction is made between president and the prime minister, is that the people of India uh, participates in the elections regarding the uh, prime minister of India. Like, for example, if we are voting in a general election, we are voting to a party who will further decide the leader of their party who will be becoming the prime minister. So citizens of India are totally involved in electing the prime minister. But in case of president, there is no role played by citizens of India in president's election, because it is done through a electoral college which consists of the elected members of the parliament and elected members of the legislative assembly. So because there we are not directly electing a party or electing the president, so that is one of the reason why president is a titular ruler, and why prime minister has all the power, because prime minister has the majority of the people, the consent of the people with him or her. So apart from executive, we have talked about just judiciary system in India. So legislature, executive, and judiciary, these three are the organs of our all organs of our government. And without these three organs, it is very difficult to run a country like India, which is very huge in population and which has a very large territory to manage. So the works are divided, and there is legislature which is making laws and rules, there is executive which are enforcing those laws and which are implementing those laws, and there is judiciary which is there to see whether all the policies and programs made by the parliament is according to the constitution or not. So the power to judiciary is that given by the constituent assembly, is that it is responsible to see whether there is any law or any act created by the parliament is going against constitution or not, because it is the duty of the judiciary to see whatever is happening, or whatever laws and rules are made in our country should resemble with constitution, because our constitution is one thing which should be taken care of before taking any decision or before making any laws. So in our judiciary, we have talked about Supreme Court, the jurisdictions of the Supreme Court, what are the tenures of the our Supreme Court judges, and what are the articles which talks about this. As we have learned that it is 65 years of age for Supreme Court judge tenure, and also a judge of the Supreme Court may resign his or her office and can be removed also because of misbehavior or incapacity. So we have also learned in our today's session that there was only once that there is an impeachment against a judge was tabled in the parliament. It was in the year 1991, and the Supreme Court justice against whom this impeachment was tabled in the parliament was V Ramaswamy. So this is all about today's class. We have read about jurisdictions, we have read about high courts. So we can say that at the union level or the entire national level, it is Supreme Court, which is situated in Delhi, the capital of India. And in high court, it exists in the states of our country. So we talked about this, and then we have talked about the subordinate courts. Under the high court there is a hierarchy, and this is all about this. And there was a judicial review which gives power to the Supreme Court to see whether it's working according to constitution or not. So this is all about today's class. Thank you.